Hey, good morning. My name is Josh Blackman. I am the president and founder of the Harlan Institute, and it's my honor to welcome you to the 2018 Harlan Institute Consource Virtual Supreme Court competition. This year, we are considering the case of Carpenter versus United States. We are now in the fourth match of the competition, and we have two teams with us. We have Will Foster and Taylor Kass from Walter Payton College Prep. And we have from Greenwich High School, Jovita Lee and Catherine Yang. The format today is that petitioners will have 15 minutes, respondents will have 15 minutes, and each team will have 5 minutes of rebuttal time. I will be keeping time. I turn over to my good colleague and friend, Julie Silverbrook, for her welcome to the competition.
Yeah, Josh, thank you as always for a wonderful introduction. I'm Julie Silverbrook, Executive Director of the Constitutional Sources Project, or ConSource for short, and we are looking forward to a lively round of oral argument for both teams. With that, I'm going to pass it over to our petitioners to begin.
Okay, petitioners, you may begin whenever you're ready, and I will keep time.
Thank you, Your Honor, and may it please the court. At issue in this case is the government's warrantless collection of 127 days of petitioner's cell site location information, revealing his locations, movements, and associations over a long period. The collection of this information is a Fourth Amendment search for two independent reasons. First, the collection violates petitioner's property right in his cell site location information, or CSLI for short. Second, the collection disturbs people's reasonable expectation that detailed records of their movements will remain private. This court's recent cases demonstrate that there is a two-part test for deciding whether a Fourth Amendment violation has occurred. As Jones and Jardines demonstrate, this court must first look at whether there has been a violation of a property right of the individual bringing the Fourth Amendment claim. If and only if there has been no property violation, this court then looks at whether there was a reasonable expectation of privacy in the data. If there was either a property interest or a reasonable expectation, then the individual bringing the Fourth Amendment claim should prevail. So first, in regard to the property right, petitioner does indeed have a property right in his cell site location information. The Telecommunications Act of 1996 explicitly names such information or describes such information as customer proprietary network information. This clearly shows that Congress understands it as law, that it is the customer's information. And indeed, the Federal Communications Commission wrote in a 1996 report that to the extent customer proprietary network information is property, it is better understood as the customers rather than the companies.
So, counsel, let me, if I can interject briefly. When you sign a contract for a cell phone, right? When you buy a cell phone contract, as did Mr. Carpenter, the contract itself says that this data may be shared with the government. You know, doesn't that contract trump any sort of expectation of privacy that Mr. Carpenter may have had?
Well, the contract would allow the company to disclose. Essentially, companies are only allowed to disclose this information to the government when they're ordered to by the government. They can't do it voluntarily because of the statutory restrictions in the Telecommunications Act. So if essentially, and orders from the government are only legitimate if they comply with the Constitution. So companies can only release this information in cases in which the government has given a proper constitutional order.
Well, counsel, let me interrupt for a minute. I mean, the government did go to a judge in this case, didn't they?
Yes, they did, but it was not a sworn application. It was a magistrate, but it wasn't a sworn application. So that's one of the important things about a warrant. And it also.
But why can't we assume that because in this case the government complied with the procedures under the relevant law, that they complied with the Fourth Amendment? Why is this not a reasonable search?
Well, it's not reasonable because the prosecutor should know better. This is extremely sensitive data. This is the kind of thing the founders were worried about. general searches for people's location over a long period of time, tells their movements, their associations, what churches they go to, what relationships they have, and this has major implications for privacy.
So, Counselor, what's your position concerning the Stored Communications Act?
Our position is that this court need not hold it unconstitutional in any part, but rather should understand it as saying, because every statute must be read consistently with the Constitution, this court should interpret the Stored Communications Act such that because there's a warrant mechanism in the act in addition to the mechanism for the lower standard that was applied by the government here, the relevant and material standard. So the government or this court should just say that the warrant standard is applicable to all searches that require a warrant constitutionally, and any searches that don't constitutionally require a warrant still go through the lower standard. And we think, of course, that this search should require a warrant. So,
Counselor, why? What makes this search distinguishable from another? Why does this one require a warrant?
Well, first, the Fourth Amendment speaks of papers and effects, and we think that papers refers essentially to any corpus of information under our reading, and effects refers to personal property. So property as distinct from real property, but obviously that's not what's at issue here. So it's petitioners' personal property and papers under the Telecommunications Act. And additionally, these are very long-term records that he clearly has a reasonable expectation of privacy in. So searches are presumptively unreasonable without a warrant of such information.
So searches of CSLI data are always presumptively unconstitutional without a warrant?
Correct.
I mean, wouldn't that actually require us to overturn part of the Stored Communications Act?
No, because at least as far as I know, the Stored Communications Act doesn't say explicitly that they can get CSLI under the relevant and material standard. I think it says that they can get certain information under relevant and material and certain information under warrant, and the government should use that provision in such a way that they are only getting under the lower standard stuff that they don't need a warrant for. And so it basically...
I'm just trying to understand where you're drawing the line for when it's necessary to get a warrant versus when it's not necessary to get one.
Well, it's not necessary to get a warrant if either there's no property interest, and again, it's questionable. Like, for example, if the Telecommunications Act hadn't been enacted, maybe there wouldn't be a property interest. Maybe the act created the property interest, or maybe it pre-existed. But additionally, so if there's a property interest, we think that they need the warrant. But if also, even if there were no property interest, if there's a reasonable expectation, which generally increases over the length that the data is collected, although we wouldn't necessarily say that like short-term information should have no protection, but particularly when we're dealing with 127 days here, we think that it's pretty clear that a warrant should be required.
So if 127 days is too much and you would need a warrant in that case, how many days would be okay without the warrant? Help us draw a line here.
Well, again, our first point is that because petitioner has a property interest in the data here, we believe that any length of time search in this particular case would violate the Constitution. But if there were no property interest, then obviously you turn to reasonable expectation and you have to draw the line. We would say probably approximately a 24-hour limit would probably be where if you're just looking at the reasonable expectation, the warrant should be required. Above that, if they want to search more than 24 hours of historical cell site location information.
Okay.
But
where do you get that number from? Where do you get 24 hours from, Counselor?
Well, the lower courts have they've been some theories. I mean, I know one lower court, I believe it was Massachusetts, held that they had a 6-hour limit, but we think that's maybe a little bit. Ultimately, if you look at it, like, people return to places day after day. So if you only look at 24 hours of cell site location information, you may not be able to make very many inferences about what people are doing. But if you're looking at like several days and you see that they're going to the same place every day, or for example, like in the present case, as the ACLU noted in its amicus brief in the court below, the evidence shows that the ACLU examined from the cell site location information shows that petitioner entered a certain sector in Detroit every Sunday at a certain time in the afternoon. And so it was a sector that included a church. So people could reasonably assume that he was attending that church every Sunday. But if you only look at like one day, you might not be able to make such an inference. So that's essentially why I mean, again, this court doesn't necessarily have to draw a bright red line rule, because we think that no matter where the line is, 127 days would clearly fall high above it. And in any case, the property interest is still our primary argument that we think controls, even aside from reasonable expectation.
Counselor, how do you think this Jones case applies in our decision here?
So in regards to the property argument, we think that Jones, and as amplified by Jardines a year later, shows that you have to, reasonable expectation of privacy is not all that that's not all there is to a Fourth Amendment analysis. You have to look first at whether there's a property interest, because that's historically been how, under like the original meaning of the Constitution and many precedents of this court from before the 20th century. So the Kass test, reasonable expectation test, it augments, but as Justice Scalia wrote, augments but does not displace the property-based test. So we have to look first at whether there's a we have to look first at whether there's a property right in the just as in Jones.
Are you there?
Yeah. What?
Oh, you froze for a minute. You're back.
Oh, okay.
Counselor, maybe I can ask a question of your colleague. How does Smith v. Maryland and the third-party doctrine play into this decision?
Just go to the front. Yeah, just like that.
Sure, which one am I looking
at? Wait a minute. Okay, if I may just start off on this one. Sorry. So Smith v. Maryland and Miller, it's much more sensitive data that's at issue here. What you're dealing with in those cases was bank records, and you were also dealing with phone numbers, and it was less data. Right now, you have a very long-term record of petitioners' movements.
But in Smith, the facts were this, right? Every time you dialed a phone number and you gave it to your phone company, you understood that your phone company would have this record. How is this different whenever you use your cell phone and you connect to various cell phone towers is transmitting your location? Why is this case any different than Smith?
Well, it's different than Smith for several reasons. First, the Smith occurred long before this court restored the property baseline in Jones and Jardines. So it essentially, the test for Fourth Amendment cases we think is different now after Jones than it is. You have to look at property first. But even if you're just looking at the reasonable expectation, we think that in addition to the less sensitive information that you had at issue there, in our opinion, also there's less of an element of voluntariness now in how people just carry around their cell phone all the time. I don't know. Did you want to talk about the voluntariness aspect?
I mean, like, for example, it says here, like, the FCC, they require, like, them to collect, like 911 records and all that. So when they collect 911 records, cell phone companies, and like that they're required by the government to do this. Doesn't this show that like the government is essentially it can, wherever a person is, the government can see where you are, and I think that we believe that that's not constitutional.
Yeah.
Violates the Fourth Amendment.
Hey, you have a minute left. You want to provide a conclusion?
Sure. Thank you. So essentially, our concluding notes would just be that we've talked about whether we think this is a search. I guess we'd also add that we think this is an unreasonable search because there's no warrant. This court should not simply defer to Congress or to let them figure it out. This court needs to apply the baseline Fourth Amendment protections that have existed since time immemorial in America, and from which our founders fought. And additionally, the balancing of interests here should support getting a warrant, because it's in many cases, in these types of cases, the government may well have probable cause already, and we just want to make sure there's that extra check that the Constitution guarantees to make sure that people.
Okay, your time's up, Counselor. Thank you very much. You finish your sentence if you want.
I think I'm fine, but thank you.
Okay, thank you, Counselor. We now have to switch over. If you can, petitioners, put your microphone on mute, and I'm going to, if you unmute the respondents, please, from Greenwich. Counselor, you have 15 minutes. You begin whenever you're ready.
Hello, Judge Blackman and Judge Silverbrook. My name is Catherine Yang, and this is my partner, Jovita Lee, and we will be arguing the respondent's side today. So first, I'm going to start with the facts of the case, and then my partner will continue with our statement of argument. So in April 2011, 4 men were arrested in connection with a series of armed robberies. One of the accomplices of the crime confessed and gave the FBI the phone numbers of the participants of the robbery. One of these phone numbers was Mr. Carpenter's. The FBI then applied for a court order to obtain the transactional records of Mr. Carpenter's phone number under the authority of the Stored Communications Act, which requires that specific and articulable facts relevant to a criminal investigation allows the federal government to access these transactional records. Based on the cell site information, the FBI then charged Carpenter with armed robbery.
So the basis of our argument is that Fourth Amendment protections are not applicable when there is no reasonable expectation for privacy. So the expectation for privacy test, established by Justice Harlan's concurrence in Kass v. United States, requires that an individual has exhibited an actual expectation of privacy and that the expectation is one that society is prepared to recognize as reasonable. In this case, there is no reasonable expectation for privacy, since Carpenter's phone records are not private property, but the property of a cell service company. Situations where there is no reasonable expectation for privacy are not protected by the Fourth Amendment, conviction that was asserted in the ruling of Smith v. Maryland. Furthermore, under the third-party doctrine, there cannot be an expectation for privacy if information is voluntarily given to a third party, such as a cell service or telephone company. Furthermore, the FBI conducted a constitutional seizure of Carpenter's cell phone data since they had a reasonable suspicion due to a verbal confession from one of Carpenter's accomplices, who had provided the FBI with phone numbers that led to Carpenter's arrest.
Counselor, let me ask you a question here, right? They went to a judge, right? They applied for an application for the magistrate. Why couldn't they have just sought a search warrant? Was there not probable cause? Why couldn't they just get a warrant?
Well, under the Fourth Amendment, a warrant is required to conduct a search and seizure of a person's private houses, papers, and effects. What the respondent is arguing is that the FBI did not need a warrant and only a court order because the transactional records belong to a third party, in this case, a cell service provider, and it was not the private property of Mr. Carpenter. And that is why they only needed to request the records through a court order and not through a warrant.
So let's talk about Smith v. Maryland for a minute, right? What were the facts in Smith?
So in Smith v. Maryland, it's the telephone.
Yes. Okay. So in Smith v. versus Maryland, telephone cell register recorded the cell phone numbers and duration and location of the calls, and the government used this information to track and implicate a man who was stalking some unnamed victim. Yes.
So, that case was decided, I think, in the late 1970s, and cell phones didn't even exist then. Is Smith still good law? I mean, does a third-party doctrine really make sense when everyone has a cell phone and every step they take, they're always transmitting data?
In the face of technological change, the third-party doctrine is necessary because it maintains the balance of privacy and security. So according to Professor Oren Kerr, who's a professor of law, he argues that a criminal can use the services of technologically developed third parties to commit crimes without having to expose these activities in the eyes of the public surveillance. But that would upset the privacy-security balance that undergirds the Fourth Amendment, because it would require police to have probable cause to obtain any evidence of the crime, which they would not be able to obtain had the third-party doctrine not existed. So according to Kerr, the effect would be a catch-22. The police would need probable cause to observe evidence of the crime, but they would need to have observable evidence of the crime in the first place to get probable cause.
But why shouldn't we impose that standard, right? In this case, the search was for 127 days. That's a lot of time. Wasn't this just a fishing expedition?
So we would like to make the distinction between a search and what actually happened in this case. The respondent is arguing that a search did not in fact take place. The data, the CSLI, was taken in retrospect over the course of the past 127 days, and under the third-party doctrine, these previous records would not require a warrant. However, had it been 127 days of data taken in real time, that would require a warrant, and that would be a search. But that is not what happened in this scenario.
So where would you draw the line then, right? How much data can the FBI obtain without having to seek a search warrant? We said 127 days, not a problem here. What line would you adopt?
So the respondent's side strongly urges the court to consider referring this issue to the legislators and to the states, because this is an issue that is constantly changing with technology, and as such, any permanent verdict rendered by the Supreme Court would take decades to overturn or years. And under the constantly changing nature of technology, it would make more sense to have the legislators and the states who, under the 10th Amendment, have police powers to keep their citizens safe, whether that is through using 911 calls to locate people in danger. Under their responsibility, it should be up to the legislatures and the states to decide this line.
Counselor, does this court usually defer to the elected branches when they're interpreting the Constitution? They would say, well, there might be a Fourth Amendment problem, but we'll let Congress figure it out. Is that how this court usually operates?
Well, generally, the court decides whether a law is unconstitutional or not. So the respondent is arguing that this is not unconstitutional, but since technology is ever changing and there could eventually reach a point where CSLI data is on as accurate as GPS tracking, it could reach a point where the legislatures or the states might need to have a rule, a more stringent.
But Counselor, your colleagues on the other side aren't saying let's strike down the entire Stored Communications Act, right? They're saying, as applied in this case, the Stored Communications Act, as it is applied in this case, violates the Fourth Amendment. How do you respond to that? That doesn't require us to strike down a whole piece of legislation. It might put some pressure on Congress, although it's no guarantee that Congress will write an update to the Stored Communications Act in light of this opinion, right?
In 2011, when Carpenter was committing the crimes, CSLI was not nearly as accurate as it is today. Our research shows that the cell service towers, they projected the Carpenter's location to an accuracy from with 1/2 mile radius to a 1 mile radius. Now that's a huge area that he could be in. And clearly it's not as precise as GPS data is today. And thus, the Stored Communications Act, considering that this is not a search of his precise location and this is not a seizure of his information, does not apply. Since there was no search and seizure, the Stored Communications Act does not violate the Fourth Amendment.
Explain that argument to me, Counselor. How is there no search of the CSLI data?
Well, there is no search of Mr. Carpenter's private property, which is what the Fourth Amendment explicitly protects. Instead, the third party, which is a self-service provider, owns the data, and the government, having a reasonable suspicion that Mr. Carpenter was involved in illegal activities, obtained a court order and requested this data from the self-service company, which they complied and gave the information to. So that is why it is not a search.
To add on to my colleague, a modern case that was decided by the Sixth Circuit Court of Appeals, Warshak v. United States, reaffirmed the distinction between the content of information and the transactional information of the electronic communications. So, for example, in a phone call, the numbers involved in the call and the duration of the call are a part of that information. However, the actual content of the call is not. And in Carpenter's case, his location information is considered a part of the transactional records, and thus there was no search.
Okay, go ahead and continue.
Okay, third party doctrine?
Yeah, sure. Okay. So we would also like to continue our argument about the third-party doctrine in this case. So the police requested Carpenter's transactional records from his self-service provider. Not only did this company possess his records, but the employees of the company had the right and ability to look at that information at any time. In accordance with United States versus Jacobson, the Supreme Court held that if say an employee of a mail company or a technology company has viewed the information, then that company has the right to disseminate that information to other entities such as the government if they have a reasonable
So Counselor, is your argument that once you sign your cell phone contract, you should understand that that material, that information is being transmitted to a third party, and so you have no subjective expectation of privacy?
That is correct. Once you sign a contract, it is important to understand the terms of the contract that you have signed.
So let me ask you, Counselor, do you have a cell phone?
Yes.
Did you read the cell phone contract?
No, but ignorance is not a valid claim to not being held to the law. For instance, if I am driving on the highway and I don't see the speed limit sign that it's 55 miles per hour and I'm driving at 80, saying I didn't know what the speed limit was is not a valid defense for my illegal actions.
Right, but just having a cell phone and having it transmit data is not in and of itself illegal,
No.
right? So, you know, the average American who has a cell phone, do you think they expect that their location, even by 2011 standards, so like within a 2-mile radius, that the police would be able to track my whereabouts within a 2-mile radius? Do you think the average American citizen is aware of that?
Well, to some extent, yes. For example, when you dial 911, the police knows your general location, and that is how they're able to locate you if you're in trouble. I think on a deeper level, most Americans are unaware that they are being tracked by their, cell service company. And under the Stored Communications Act, the government doesn't automatically have access to this information unless they have specific and articulable facts that it is relevant to a criminal investigation.
Okay.
We got 2 minutes left, Counselor.
Okay, would you like to continue?
Shall we discuss USV?
Okay, so we would just like to briefly touch on the property right and reasonable expectations that our honorable colleagues mentioned on the other side. So first, we argue that there is no reasonable expectation of privacy in this case because
So under U.S. v. Miller, Justice Joseph Powell asserted that documents subpoenaed are not private papers, but rather the part of the bank's business records, and thus Miller, in this case, had no reason to expect privacy with his bank records.
So, for instance, if you imagine Mr. Carpenter's phone records, the content of the calls were his private property. However, the transactional and location data belonged to the self-service company, and thus it was not his private property information, as our opponents would like to argue. Furthermore, there is no reasonable expectation to privacy. For instance, society recognizes that nothing is completely private on the internet, which is why, for example, in United States versus Maragildo, people have a reasonable expectation of privacy in the contents of their personal devices, such as their cell phones, but communications disseminated through a third party, such as social media, internet, or a self-service company, can be accessed by the government and your third party if they choose to do so, if they believe that you are involved in criminal activities.
Okay, about 30 seconds left, you can wrap up.
So, in conclusion, the basis of our argument is that there was no reasonable expectation for privacy, and there was no search conducted and no seizure, and thus the Stored Communications Act does not violate the Fourth Amendment. And the access of Carpenter's phone records, those were constitutionally obtained, and due to the fact that there was no unconstitutional government intrusion.
Considering that it was not a search of Mr. Carpenter's private property, a court order was sufficient enough and a warrant was not needed under the wording of the Fourth Amendment. Thank you.
Okay, thank you, Counselor. All right, right in time. Counsel for the respondent, we're going to put the respondents on mute. And if Counsel Petitioners can unmute yourselves, please. Okay. And you have 5 minutes. Begin whenever you're ready.
Okay. First, we'd like to respond to their comments about the reasonable expectation of privacy. So they claim that people should know that their information is being available to these companies and could end up in government hands. But the Empirical Scholars Fourth Amendment brief, this was an amicus brief filed in the Supreme Court, shows that people actually do expect subjectively privacy in this information from survey data. This is empirical data. Additionally, in regards to the private property aspect, which again we think should be the primary.
Counselor, before you move off of the survey data, can you tell us what the survey data showed?
It showed that a majority of Americans, I believe it was like 70% or 80%, believed that this kind of information of their location was not. They expected that it was private information, and they did not realize that it was available to companies and the government. So this shows a subjective expectation of privacy. And additionally, in regards to the property aspect, we still don't find the government's arguments on that point convincing because, again, the Telecommunications Act language calls it basically the customer's property. And additionally, in regards to the third-party doctrine, we think that the government's argument leads to absurd results when applied to, let's say, emails, for example. So first, their basic argument is that you have no reasonable expectation of privacy in stuff given to a third party, but emails are given to a third party. So then they come up with the distinction between the content of a communication and the routing information. But the problem with that distinction is that essentially they say that because companies have the right to look at the location information, but not the actual contents of like communications, then it's okay for the government to look at the location, but not the contents. But as it turns out, that's not how emails work. Would you like to explain a little bit about Microsoft and?
So yeah, Microsoft says in their terms of use, quote, the terms of service currently applicable in Microsoft's free email service assert Microsoft's right to access and use the contents of its customers' emails. Likewise, Google states in its terms of service that it accesses the contents of emails to provide, quote unquote, customized search results, tailored advertising, spam, and malware detection.
So ultimately, you can't draw a reasonable distinction between this content and non-content because the companies themselves can look at your content of your emails, but that doesn't mean that the government should also be able to look at them. Essentially, the third-party doctrine just ends up leading to really absurd privacy value. I mean, where do you draw the line? I mean, can the government take fitness data from your smartwatch? Can it take your entire Google browsing history? Can it take
Counselor, but what if we draw the line? We say location data that is being obtained, through the mechanisms of the Stored Communication Act, that's okay. Content of email, that's something different that requires a warrant. Why can't we draw that line?
Well, I guess it's just we would submit that that's not a reasonable reading of the Fourth Amendment, because the Fourth Amendment is it doesn't draw any such distinction. I don't think that we can. This distinction just doesn't seem like something that fits it seems like kind of an ad hoc exception that's just added on to make the third-party doctrine more palatable. But in reality, the third-party doctrine is doomed to fail in the digital age, and we need to reconsider that. Additionally, in regards to the point about the accuracy of the data, again, it's important to remember that while this data is not well, I guess the main point is that we already explained how you can make reasonable inferences from the data, but more broadly, since the government essentially says that you have no reasonable expectation in data you give to a third party, it would not seem to matter under their theory how precise the location information is. For example, if they had GPS data that could pinpoint people to 1 square foot, that would be given to a third party, then presumably the government could still take it under the Stored Communications Act. Again, unless you draw some ad hoc exception, but we don't think that's the way to go. We think you have to be very strong and categorical.
Yeah, and the other side, they stated that the location data, the cell data, it could only pinpoint within a mile. In the amicus brief for this case, tech experts said, quote, "These towers could be accurate up to within 50 miles or less." So that is really specific location data.
50 meters?
50 meters, yeah, 50 meters, yeah.
Okay, Counselor, you're out of time, but thank you for that. All right, please put yourselves on mute. And respondents, please unmute yourself. You have 5 minutes whenever you're ready.
Honorable judges, first, the respondent would like to address the point that the petitioner made about people expecting subjective privacy. However, in cases of criminal activities, people expect the government, under the police powers that they are granted, to act. For example, in the recent case with the Austin bomber, government agents were able to obtain his location based on CSLI data after looking at the FedEx truck license plate. They were able to trace his phone number and obtain the CSLI data. There was no objection in this case because the government had specific and articulable facts that this man who was terrorizing the city of Austin was connected to criminal activities. And this is the point we are arguing today, that under the line that the Stored Communications Act currently sets, where the government can only access the transactional data requested from a third party if they have specific and articulable facts, this is constitutional under the Fourth Amendment.
But Counselor, is it constitutional for 127 days? I mean, if you're looking at CSLI data, I think your colleagues on the other side had suggested a 24-hour line. That's fine, right, under the strictures of the Stored Communications Act. But anything beyond 24 hours, you would need a warrant. Let me ask you this question this way. When would you need a warrant to search CSLI data?
You would need a warrant to search CSLI data if it was what we'd like to call real-time data, which is like GPS tracking or collecting the data as it's being transmitted, like in real time. However, in the case of Carpenter, it was historical CSLI data where they went to the historical backlogs of the self-service company to obtain this information.
So so does that mean that they could search, all of his CSLI data that he had ever acquired, in the time that he had the phone from T-Mobile?
Well, this is a distinction that should be left up to the states. In 2011, considering the CSLI data was not so accurate, and pertaining to the case, the government should just look into the information as far as they deem necessary with regards to the crime that was committed. However, considering the improvements of technology that are made consistently as CSLI, the accuracy of that information and the precision approaches that of GPS positioning. Well, GPS data is different. According to US v. Jones, it is unconstitutional to collect that type of information to that degree of precision. So as CSLI data approaches that, that is a distinction that must.
So let me ask you for a point of clarification, though, because you just said this should be left up to the states, but you've also, your argument hinges on compliance with a federal statute.
Yes, we also, to clarify what my colleague said, either states or the congressional legislature.
Okay, so do you think that the Stored Communications Act needs to be amended now that the CSLI data actually gets, 2018 versus 2011, we have much more accurate location data now based on that, right?
Yes.
Yes, but with relation to Carpenter, the case should be decided based on the 2011 technological capabilities. So may we continue with our argument?
Go ahead. Go ahead.
Thank you.
So to rebut the petitioner's point that in the survey that they mentioned that 70 to 80% of people expect privacy in their CSLI, well, the thoughts of the majority of Americans is not necessarily reliable. For example, in a study we found about 66% of people think that the First Amendment of the United States regarding free speech and freedom of expression actually protects their right to vote, which is frankly untrue. So basically the point that we're trying to make is that the ignorance of a people who have signed off to something that they're not entirely sure of what they signed off to is not a reasonable expectation.
Okay, Counselor, you're just about out of time for a wrap up. Give a few more seconds for conclusion.
Okay. So in conclusion, the petitioner's argument that there was a property right and there was a reasonable expectation is voided by the fact that the third-party doctrine and the fact that people cannot claim to ignorance as a way to circumvent this third-party doctrine makes the fact that Carpenter versus the United States, the court order was needed and not a warrant because there was not a search conducted, and therefore it does not violate the Fourth Amendment. Thank you for your time, judges.
Thank you. Well, I'd like to thank both teams for their wonderful participation. Julie and I have run this competition now for several years, and by far this is the strongest crop of candidates we've had. You continue to make us proud and give us hope for the future of our republic, that there are people who are committed to civic virtue and the Constitution. Julie, would you like to add a few words?
Yeah, I just want to echo what Josh said, and then I would also like to just give a little bit of information about when you should expect to hear back from us. So we have 2 more rounds left, so you will hear back from us by the end of this month, the 30th or 31st approximately, with whether or not you will be advancing to the championship round, which will be held on April 26th at Georgetown University Law Center in Washington, D.C. So we will keep all of the teams really posted about that, and I just want to echo Josh's note of congratulations.
Thank you, Julie. Thank you for the teams from Walter Payton College Prep, and thank you to the team from Greenwich High School. The court is now adjourned. Thank you.